Greetings. My name is Jelani Bland, and I am a fourth-year criminal justice major from Springfield, Massachusetts. My topic today is warrantless searches and seizures. I picked this topic because I believe it is very significant in our day-to-day lives, and it is a topic that everyone does not quite understand. By definition, a warrant is a document issued by a legal government official authorizing the police or some other law enforcement or body to make an arrest, search a premises, or carry out any action related to the administration of justice. Warrants require police officers to commit to a factual story justifying their issuance before acting on it. This means just because a police officer may believe something is going on, they must get facts that support theory before they can just go out and arrest everyone because they believe that a crime is being committed. Although warrants are necessary in most searches and seizures and arrests, warrants are not always needed to conduct a search, as some may believe. The Fourth Amendment is the amendment that protects everyone against unlawful searches and seizures. There are a few exceptions that apply in situations that give law enforcement a right to search you if necessary. There are 11 different instances where warrants aren't necessary for searches or seizures, and these are plain view searches, search incident to arrest, vehicle searches, booking searches, inventory searches, consent searches, administrative searches, exigent circumstances searches, special needs searches, and stop and frisk. Plain view search is when the police are somewhere they have the right to be legally and see something illegal or something wrong taking place. They do not need a warrant to intervene. Horton versus California states that plain view applies whether police expected to find what they observed when the search began or not. For example, if an officer enters a private apartment with no warrant and no legal justification, and once inside sees illegal drugs, those drugs will be inadmissible at trial because the cop's conduct in entering the apartment was illegal. But if a cop is conducting a normal, routine traffic stop and sees marijuana or other paraphernalia out in the open, they do have a right to search the vehicle. Search incident to arrest is when every time a police officer arrests a suspect, they have a right to conduct a search of the suspect in the area within the immediate control. The scope of the search is limited to the area where the suspect can obtain the means to escape, harm someone else, or destroy the evidence. Based on Thompson versus Louisiana in 1984, searches conducted without a search warrant are per se unreasonable under the Fourth Amendment. Arrest warrants also aren't necessary if you're making a public arrest. They are only necessary if you're trying to arrest someone who is in their own home. Probable cause is the most vital key factor when it comes to vehicle searches. Probable cause alone justifies an officer to search a suspect's vehicle. Even the passengers of the vehicle have a lower expectation of privacy in the vehicle because they can also be concealing evidence in a crime. Probable cause allows the officer to search the vehicle on the street or in a different location at a different time, according to Chambers versus Maroney in 1970. There are many other instances where warrants aren't necessary for searches. These are a few examples where law enforcement has the right to act based on their perception. There are many cases that relate and can be used when it comes to this topic, and I have researched and listed a few. Number one being Riley versus California, 2014. The court unanimously held that the warrantless search and seizure of digital contents of a cell phone during arrest is unconstitutional. The court also held that information accessible via the phone but stored using cloud computing is not even on the arrestee's person at the time of being arrested. The second case study is Minnesota versus Dickerson, which simply states there is no expected privacy with contraband that can be seen by law enforcement in plain sight, which goes back to the plain view doctrine. Thompson versus Louisiana, which I briefly touched on, states that searches without a warrant per se are unreasonable under the Fourth Amendment. And lastly, Vail versus Louisiana states that an arrest outside of a home does not justify a search to an adjacent home as an incident to arrest. Just like anything in life, this topic comes with pros and cons. A few pros can include cops can prevent crimes and harmful actions against others if they take the correct preventative steps necessary, which don't always allow them to wait for a piece of paper. With these exceptions, cops are also safer in their day to day life conducting traffic stops, knowing that if they need be, they have the right to search and arrest people who may have committed or plan on committing crimes. The third pro is simply being criminals having a harder time getting away with crime, knowing that there are so many exceptions and law enforcement has the right to search and make stops. And they feel that a crime is really taking place. On the other hand, a few cons include that cops profile and discriminate against certain groups who are perceived more likely to commit crimes, meaning that they will target a certain group based on their perception of that group, thinking that they are more likely to commit a crime. Some, but not all, cops will also use this to their advantage when dealing with people who don't necessarily know all of their rights and can confuse and persuade citizens into searching them unlawfully. And finally, one of the biggest disadvantages is probable cause because it is such a broad and ununderstood term that is still being argued to this day in the criminal justice system by criminal justice professionals. Thank you all and have a blessed day.